Hello, good afternoon. Welcome to the law. This is your legal light. It is your help law. And this afternoon, the very controversial LI, legislative instrument, passed in November of 2022, Environmental Protection Mining in Forest Reserves, Regulation 2022, famously LI 2426. Do you know exactly what is in that LI? You've heard the arguments back and forth that it has to be revoked, and the government has only resorted to amending it in breach of its promise to actually revoke it. That is, completely obliterate it. So what exactly is in that law? And why is the insistence on revocation and not an amendment? Why is the amendment not a cure to the problem that civil society has been crusading against? I've got two lawyers. We're looking at two courses: amendment or revocation. One defends the controversial provision as freshly stitched, as in amended. The other has been on a campaign for a long time now for a repeal. Roots, stick and branch, no glitch. One sees reform in ink. The other sees betrayal in green. We will talk pure law. I'm Samson Ladi Anyanini. We'll be right back. You're welcome back. This is the law. It's your legal light. It is your help law. And I appreciate the interest generated in this particular discussion because of the politics that have, surrounded it. But on this program, we don't talk politics. We talk pure law. We help you with platinum legal education. My guest, Clement Kujoakapam, is senior lecturer at the GIMPA. He teaches law. He's also in private practice with Taylor Crabb, barristers and solicitors. And Kingsley Eko Gurase is also in private practice. He does some other work, but for this purpose, he's here in his capacity as a private legal practitioner. Gentlemen, thank you so very much for making time to join us here on the law this afternoon.
Thank you.
Yeah, thank you very much, Samson.
Great.
Thank you.
Thank you so much.
Pleasure.
Right.
Thank you, Samson.
Let's begin by trying to share with our audience the Environmental Protection Mining in Forest Reserves Regulation 2022, which was passed into law in November of that year. It's known as the LI 2426. And the most controversial portion of that law is Regulation 3, Sub-Regulation 2. So this is the law which has generated a lot of controversy in this country ahead of the elections and after the elections. And here is the Section 3 as marked, as you can see. Section 3 says prohibited areas. Section 3.1 says a person shall not issue a license or permit to any person to undertake mining activity, including exploration activity in the following areas: a globally significant biodiversity area, a protected provenance area, an institutional research plot, a hill sanctuary, a high conservation value area, a seed orchard, swamp sanctuary, plantation sites and cultural sites. This is the list of places that are prohibited. So you cannot have license to mine in those areas. It is the introduction of the sub-regulation 2 that brought the problem we are seeking a solution to today. The sub-regulation 2 says, despite paragraph A of sub-regulation 1, the President may, subject to Article 268 of the Constitution, give approval in writing to a mining company to undertake mining activity in a globally significant biodiversity area in the national interest. Clement Akapam, let's begin with you. What is problematic with this provision? In the national interest, the President may give permission or approval for mining in a forest reserve, a biodiversity area globally. What's wrong with it?
So, Samson, thank you. And thank you very much for this opportunity. I think that you have actually zoomed into that regulation, but I think that the basis for questioning the entire legislative instrument goes beyond. I would like to build my argument on the fact that in forest reserves, ongoing for a very long time, as far back as 1996, a discussion commenced to ensure that companies that were undertaking exploration activities in forest reserves were given a certain operational guideline to work with. Then fast forward to May 2001, these operational guidelines were further expanded based on stakeholder consultation, based on industry consultations, all in the national interest to ensure that we are able to balance our mineral resources and our commitment to protecting the environment. So in May 2001, there was this elaborate guidelines put in place. Now, the guidelines were very specific that mining will happen only. Now, this is what it means. It means that mining will only be permitted where timber logging is also permitted. Now, the guideline, being very progressive in its thinking and trying to balance uniformly our environmental commitments and our interest of raising revenue for the state, indicated expressly that only 2% of the total area of production forest reserve will be open for mining. 2%. Then now we get into 2025, 2024, 2023, 2022, and we're seeing a certain level of mining, and appears LI 2462. The first question I asked myself as a researcher is, what is the legal basis for those regulations? That the legal basis for those regulations is anchored on the Environmental Protection Agency Act, Act 490, as now repealed, the general provision Samson, it will interest you to note that the Environmental Protection Agency does not clothe the EPA with legislative capacity. So the question is, the first point we need to deal with in this discussion is there a legislative basis for those regulations? If there is no legislative basis for those regulations, it means that whether or not the regulation is good or bad for a legal researcher is wrong. And I'm coming from a very pure Austrian positivist position, where for delegated subsidiary legislation, you must point to a parent act that clothes you with authority to pass that legislation. So for me, on the first foot, the legislation and the ministry that sponsored that subsidiary legislation lacks the capacity to do that. So that is where my debate starts from.
Okay.
Then I go like, okay, let's say that the EPA can rely on that general provision in its Act 490 and go on and pass this regulation. Let's go into this legislation and see what it does. Dissonance. You begin to see confusion and conflicting provisions with existing laws meant to regulate how we manage our natural resources. You see fees being charged with no legislative basis. So we start questioning the validity of those. And on a number of occasions, we have been on this campaign since we first saw this and said, no, this law cannot be the law we used to regulate mining and forest reserves, because even when we had the guidelines, our forest reserves, the production forest reserves, were better managed. And then we were told that, yes, this will be repealed, revoked, and that a process even had started prior to the expiration of the last parliament. My views on that process. Thursday, we got indication that the law has been amended because it has passed the mandatory 21 days sitting in Parliament for an amendment to take place. What does this amendment seek to do? The amendment seeks to take away the presidential power to grant mining in those lists that you gave, globally significant biodiversity areas, hill sanctuaries, the list goes on.
Right.
The question is, can this revocation or the amendment of this provision strengthen in where in Ghana? The answer is no.
State,
so this amendment is cosmetic.
State that again. State that again.
Use.
Pose the question you posed before you began to give the answer one more time. Hello, Clement.
The question I'm asking.
Good.
Is that is
we have a bit of a challenge with your line.
Amendment.
There's a bit of a challenge with your line. I don't know why. I don't know why, because particularly the jurisdiction where you are talking to us from, you should have the cleanest, connection. But we don't know why there is this interruption. You appear to freeze briefly and then come back. I don't know what we can do about that, but you hold your thoughts at this point. We note that the question you are asking now is whether the amendment that has now been done, and this amendment has been done with LI 2463. So LI 2462 has now been amended by LI 2463. And the amendment is in respect of the Regulation 3, Sub-Regulation 2, the one I projected a while ago for you to see. Regulation 3, Sub-Regulation 2. Sub-Regulation 2 is the provision that grants the president power to, despite the prohibition that you cannot mine in globally significant biodiversity area, you cannot mine in a hill sanctuary, you cannot mine in an institutional research plot, you cannot mine on plantation sites, you cannot mine on cultural site or swamp sanctuaries, a seed orchard, and so on, protected provenance areas. Despite that prohibition, that nobody can get a license to mine in any of these places, it is section sub-regulation 2 that grants the president a power to decide that he can give an approval for some entity or person to mine in those areas. And this is what the campaign has been against. Now, this provision has now been amended by LI 2463, which takes away the power given to the president to approve for mining in these prohibited areas. Clement asked the question, does this provide the cure? That's the question we are going to ask. And I'm going to hear from Kingsley also. But before we hear from Kingsley, the Ghana Academy of Arts and Sciences, has written a letter to President John Mahama. It's dated June 18, 2025. And we're scrolling this letter for you. There are some bullet points they make which confirm the points that Clement Akapam has just made. So, here is what they say. This is the place of professors in our, high learning institutions who take their time and brood over materials and so on. So they say why LI 2462 must be repealed in full. So you see in the first bullet point, they say it is unconstitutional. That's the point Clement was making. It is unconstitutional. The law gives power to the minister and president that properly belongs to the Minerals Commission, violating the clear constitutional boundaries. Bullet number 2, they say it is it's legally flawed. Clement has made that point, but he's going to reinforce it. The minister who introduced this LI delegated powers he did not have. The president cannot legally be granted mining approval powers in forest reserves without Parliament's explicit direction, and only on the advice of the Minerals Commission under Article 2692 of the Constitution. Bullet number 3, it will destroy our environments, it breaks international promises, and 5, it puts future generations at risk. We are dealing with the law, so we stick to the legal aspects. Now, Kingsley, by the amendment, is the problem not resolved?
Thank you, Samson. Thank you to your cherished listeners. Now, before I would like to make some general statements before I come to the LI 2462. Now, mining itself, mining is an undertaking, meaning it's an activity So irrespective of the environmental medium in which it is done, a person must obtain a mineral right first from the Minerals Commission and the Lands and Forestry. And then in our the law of regulating that is the Constitution, Article 2576, and then Section 5 of the Minerals and Mining Regulation Act 703. Now, the person must also obtain an environmental permit. So even if the person were mining, for instance, if we find mineral in the sea, the person will still be required to obtain an environmental permit from the EPA. Now, what will happen likely in that instance is that EPA will do an airline to regulate the mining activity in the sea. But then, Samson, mark carefully, the permit that will go with it will still be on the basis of LI 1652, which is the law regulating environmental impact assessment. So whatever the medium is, obtaining an environmental permit is based on the LI 1652, Environmental Assessment Regulations of 1999, LI 1652. So in the same vein, when you are mining, so it's immaterial that when you look in the EPA LI 1652, you don't even see mining in forest reserve there, because you see the EPA regulates the undertakings irrespective of the medium, and mining is an undertaking. Now, when you come to the LI 2462, you look at the purpose of the regulation. That's section regulation 2. Samson, with your respect,
it says the purpose of these regulations is to provide for the environmental management of mining activities in forest reserves through efficient use and protection of natural resources, effective stakeholder consultation and participation on issues relating to mining in forest reserves, effective and efficient administration and disbursement of the 0.6% of the value of minerals mined and paid as the environmental and ecological services commitment by mining companies operating in forest reserves. Provide for the modalities for assessing and the disbursement of the portion of the funds meant for the development of the local community. Ensure that benefits of the local community from mining in forest reserves are maximized. Provide for controlled mining in the permissible area of forest reserves in the country. Provide the criteria to address environmental constraints, challenges, and issues related to mining within forest reserves, and identify environmental management tools which promote environmental protection and stakeholder confidence.
Absolutely. So, Samson, you see that nowhere in the purpose is the grant of an environmental permit, which, when you turn to Regulation 15, is there. Regulation 15, respectfully, if you can, just so environmental permit.
All right. Now, I think I'll go to Clement whilst you look for this.
No, I have it. I have it.
Okay, go ahead.
So a mineral environmental permit, a mineral right holder shall conduct an environmental impact assessment in accordance with the Environmental Assessment Regulations 1990, LI 1652, for purposes of obtaining an environmental permit. So what this means is that it is the LI 1652 which is responsible for the grant of an environmental permit. So whatever the person does, the permit will be issued under the LI 1652, not under the LI 2462. So to take away that law to take away the whole of that law is then to take away some regulatory measures, which, for instance, it states that, let's say,
where it says the purpose of this regulation is to provide for the environmental management of mining activities in forest reserve through efficient use and protection of natural resources, effective stakeholder consultation. You are saying that if there's a repeal, then you take away all of these provisions.
Without even giving any permit. Because you see, this law doesn't give permit. And you see, the main thing about the crux of the matter is, it's like, to give a literal example, like you owe somebody, and then the person has come to take your son away. If he takes the son away, it's not your son who he owes. You see, if you repeal that law, you haven't taken away the power to give environmental permits, because that's grounded in on LI 1652. So a repeal of that law has nothing to stop the grant of environmental permits, irrespective of where it is done, whether it's in a forest reserve, it's in the sea, it's other, because it will all be based on the LI 1652. So that's the fundamental thing. You see, the grant of environmental permit by the EPA is based on the Act 1124, the current Act. And then the LI 1652. The LI 2462 merely comes in to regulate and give some guidance, because this was, like Clement said, it was first in the form of guidelines, which were converted into this LI. So in order to give a legal teeth to it, so the guidelines which will guide mining in forest reserve are still the crux of the matter of LI 2462, but not to go ahead and give permit. So it doesn't give permit. The LI 2462 doesn't give permit.
So
now,
as far as you are concerned, the question I asked you was, the amendment is all we need to do, which has been done, nothing more. Is that what you're saying?
Yes, because see, why the amendment itself, if you look at the 3.2, you see that when you look at the purpose of the LI, it's not supposed to go into the grant of environmental permit, where you can mine and so on and so forth, because that is by other enactments, like the Minerals and Mining Act, and then the LI 1652. So for the 3.2 even to purport to go into grants, and they said it's an overreach of those enactments. It's an overreach of both LI 1652 and Act 703, and it's in excess of its purpose. Yes, so that's why it's in order that this law, this section is amended. It's not unconstitutional, because you see, to give a mineral right is guaranteed by the Constitution. So if you want to stop mining in the forest reserve, then all you have to do is to amend the Constitution.
Okay.
Interesting.
Okay.
You see, amend the portion of the Constitution.
Clement comes in and he has such a clear line. Let me get to him right now. So Clement, what do you say? Kingsley is suggesting to us that this particular regulation has a purpose. And in the purpose for which it was made, you count about how many purposes, so to speak, from I to up to F, including providing for controlled mining in the permissible area of forest reserves in the country, providing for the modalities for accessing and the disbursement of the portion of the funds meant for the development of the local community, among other things. Beyond that, if you read further, it has other provisions. Regulation 4 says a person shall, before undertaking a mining activity in a forest reserve, obtain sequentially the permits and approvals specified in the first schedule. And the first schedule is here. Kingsley is saying that to mine, you need to follow a certain process. And this is not the law that allows you to do that. So repealing this entire law is not the solution. The problem was identified as giving the president that power. That power has now been taken away from the president. What else do you want?
Something interesting. It's not about want. I think it's about what we have all agreed.
That's right.
As the standard for the management of our natural resources, balancing our developmental needs and our commitment to protecting the environment. Now listen, the argument that Kingsley makes actually goes to ground the fact that LI 2462 is needless, is pointless. The president already, under the Minerals and Mining Act, has the power through executive instrument to declare every area in Ghana, including Samson, your house, if we find a mineral resource there, as a mineable area. So this LI that has led to the granting of forest entry permits into our forest reserves is what is causing the problem. And that is what we are asking, that remove this LI, take it off your books, because one, the EPA lacks legislative capacity to pass this LI. Two, the LI conflicts with what we have set up of Parliament regulating mineral resources. It conflicts, there is a dissonance, it's illogical in its provisions. Something, go specifically, and I want you to read that. Go to Regulation 25 of this LI. And I'd like you to read Regulation 25 and what it says.
Regulation 25. Regulation 25 says that functions of the finance subcommittee. The functions of the finance subcommittee is to advise the steering committee on the financial management of the 0.6% environmental and ecological services commitment paid by a mining company operating in a forest reserve.
Listen to this. This is a commitment fee that is supposed to be paid as reserve. This by even this LI. The first time we see this commitment is through regulation.
Okay, Clement, your line, unfortunately, your internet is not helpful at all. I think production will determine how else we go about this. Either we get a direct line and just speak to you on a direct line rather than a Zoom connection and see whether that gets better. But Kingsley, don't you see the issue here that apart from the Regulation 1, or is it 2 that you refer to, all and every other part of this particular LI is about mining in forest reserve, regardless of how it dictates how to do so and do so responsibly. Don't you understand why the campaigners say the entire regulation should be removed, should be revoked, rather than amending just the portion that gives the president power to grant permission to mine in a forest reserve? Hi, Kingsley.
Yes. When you come to Regulation 6, it talks about exploration activities in a forest reserve. and it gives guidance as to how that should be done. It's a lot. Exploration activities in a forest reserve. You come to Regulation 7, it talks about construction of access routes, bridges, tracks, and drill grade. Regulation 8 talks about excavation and drilling in a forest reserve. So these are all regulations to supplement what is already in the LI 1652. You see, so to take it away will leave gaps. So that's why it should be there. Because this is specific to mining in forest reserve.
Yes, and the question is that we don't want, that's the crusade, we don't want mining in forest reserve. The president has, by this law in Regulation 3, Sub-Regulation 2, been given the power to grant approval for mining in forest reserve. We say we don't want you to get that power. We don't want mining in forest reserve. So you do an amendment and you take only that power away. But you leave provisions that regulate how mining should be done in a forest reserve.
Yes. Samson, you see, the power to grant mineral rights for mining in a forest reserve is vested in the Constitution. So, till you take away that right, and you know, one thing people must know is it is almost a principle of customary international law that the sovereign has access to its natural resource, which has found expression in the Constitution. So, if we think Article 2576, if we think there should be no mining in forest reserve, then all we have to do is to stop the grant, which is an executive order. If there is no grant of a mineral right, there will be no environmental permit and there will be nothing. You see, but once that thing has not been curtailed, they better keep this, because once the grant is made, then whoever goes into the forest reserve must be guided by the Regulation 6 on how to conduct responsible mining. So that's all this seeks to do, because this is not what is giving any mineral rights or environmental permits. This is just an elevation of the guidelines into regulations. So it must be there. If it's there, it must be there so that in the event that we are not able to take away the president's power, the president continues to give the mining mineral rights.
The president power has already been taken away. Which was
from here.
I'm talking about the exemption through Regulation 3, Sub-Regulation 2 has already been taken away by the amendments.
But Samson, it's not been taken away from the Constitution.
That's correct.
But that's where it springs. So even this one, some argue that it's even unconstitutional to restrict the president's power because it's based on the Constitution itself. So the power to grant a mineral right is guaranteed by the Constitution. And it's also guaranteed by customary international law that the sovereign must have access to its natural resource, which has found expression in the Constitution. So if we think we don't want that, then you take away the grant, the power of the president to grant mining in forest reserve. If there is no mineral rights granted by the president, then all of these things, I mean, there will be nothing, you can't go to the forest reserve when you don't have a mineral right to start with.
Thank you, Kingsley. I've got Clement back. Clement, thanks for your patience. Now let's go to the arguments you were making, very substantial ones at that, on the question, if you revoke this entire LI, then you are taking away provisions that are needed to also safeguard our forest reserve. What the call has been was to remove the power of the president to give approval, and that is removed by the amendment. But even that, Kingsley is pointing to even a constitutional power that you can't do anything about. What do you say?
So, Samson, that's why we're saying that this LI is useless. is of no legal significance. It doesn't add any benefit to our management of our natural resources. If you take this LI away, Kingsley and his group can still undertake their environmental impact assessments anywhere. The Forestry Commission will be able to give entry permits. All the agencies.
Oh no. This is strange. Just when we got a clear line to him, the call dropped. We will raise him back on the line. Thank you very much. This has been the Law. It's your legal light. It is your help law. And we are trying to give some education, looking pure into law to see what the problem is with LI, the infamous LI 2462. Even though an amendment has happened that has removed the power, discretionary power to the president to grant permission for mining in forest reserves. And as you understand from Clement, this was actually needless because it came to supplant other, constitutionally provided or even statutorily provided powers which the president could exercise anyway. That takes me to a very strange place. Where are we getting to? If by removing this, we have not taken away the power of the president to grant power to mine in forest reserves, then what is it? Clement, you are back. Thank you very much. Please, let's have you continue to expand your point.
Samson, the point I'm making is clear. We all want our resources to be managed efficiently, sustainably for the benefit of all of us. If you take LI 2462 through the lenses and you do an analysis, you realize that this LI was just put in place to achieve a certain aim, which is clear. The jury is out there. The point I'm making is that if you revoke this LI, nothing will happen. If you amend this LI, there is still a provision in that LI that allows a certain liaison committee or steering committee to manage a certain 0.6% of our mineral resources paid by mining companies without taking it through the processes we have put for the management of such resources. That is the tanker of this LI. This LI does not serve to protect any mining anywhere. It doesn't serve to set any guidelines whatsoever in practice because the jury is out there. When we had only guidelines in 96, 97, and 2001, these guidelines had no legal backing. Our forest reserves were protected better than when this LI was passed. My argument is based on the fact that the EPA, in seeking to be the agency that sponsors this regulation, is problematic. And immediately we raise this issue, you realize that in 2025, when they passed the new Environmental Agency Authority Act, quickly in their regulations, they will indicate that in Regulation 43H, they will indicate that now the EPA has authority to pass regulations for mining in forest reserves. It's in the new law. So if you have an LI that lacks legislative capacity or legislative grounding under Act 490, and Act 490 has been repealed and replaced with Act 1124. And now Act 1124 has clothed the EPA with authority to issue such guidelines. What is the proper thing to do? The proper thing to do is to start afresh, have a clean slate, revoke the LI together with Act 490, and undertake proper consultative processes with all stakeholders, industry, civil society, chiefs, and come up with regulations for mining standards wherever. In forest reserves, in Samson's house, in my father's village, in Riaga, wherever. That is the approach. So we cannot end something. For me, as a legal researcher, the point I make is that you cannot put something on nothing. Maybe the intentions are noble, but the foundation is weak. And if the foundation is weak and is bereft of legal grounding, let's do the right thing. It is even wrong for teachers of the law to be teaching in the classroom and telling students that subsidiary legislation or delegated authority is based.
Okay. We'll raise Clement back one more time. Thanks for joining us. And what you're seeing on the screen now is the statement that was issued by the Ghana Coalition Against Galamsey. Ghana Coalition Against Galamsey, which has membership of, there are so many of them. One Ghana Movement, Ghana CSO's Platform, Brace, CASA Initiative, Peasant Farmers, General Transport, Petroleum and Chemical Workers Union, Institution of Engineers and Technology Ghana, Ghana Institution of Engineers, Graduate Students Association, Media Association of Ghana, Ghana Institute of Architects, Institute of Public Relations, Ghana Institute of Foresters, Africa Center for Policy, Energy Policy, Chamber of Agribusiness Ghana, Research Scientists Association, University Teachers Association of Ghana, UTAG, Ghana Mine Workers Union, and so on. Kingsley, as we get ready to wrap up, do you appreciate the point by Clement that this was not a regulation that was needed in the first place? Because by your own argument, that's the conclusion, isn't it?
My argument points to its relevance. It's needed to, it's a specialized area. So, for instance, if there is mining, like I said from the onset, if there is mining in the sea, for instance, and we find minerals in the sea, and then we want to mine it, then we may end up doing a regulation to guide the process. And that regulation will be specialized and supplement what is already there in the LI 1652. But then that regulation will not have the power to give any environmental permit. So this is specialized regulation. When you look at regulations 6 going.
So Kingsley, the president's power or the permission that's granted him, which has now been removed, it applied to the prohibited areas only.
Yes.
The prohibited areas in Regulation 3 sub 1.
Yes.
That's which by the arguments of the experts, that forms only about 10% of Ghana's forest. If you leave this regulation intact, what you mean is that the remaining 90% of our forest becomes vulnerable.
No, Samson. Is it because this regulation doesn't give anything? It doesn't give, neither does it give mineral rights, nor does it is the basis of the grant of environmental permit. So if you remove it, it doesn't stop EPA from going ahead and giving environmental permits on the basis of LI 1652. So this regulation itself is not the cause of the proliferation of the mining activities.
But we saw just when this regulation was made in November 2022, we saw, hordes of applications that are just immediately being granted on the back of this regulation.
Not on the back of this. You see, when these regulations didn't make any grants of either an environmental permit or a mineral right. However, it was capitalized. You see, because to get all those things are executive. They are executive directives or orders. So, for instance, to grant a mineral right is based on the Minerals Commission and the Ministry of Land. So, if they give the mineral right on the back of this LI, it's unfortunate. You see, because this this LI 2462 is not the regulation which triggers any mineral right, nor is the basis for getting an environmental permit. It is just to protect the forest once those things have taken place. So once there is no grant of a mineral right, and nothing happens, really. You see, the 3.2, which has been amended, it's good to be amended because, like I said, it's even in excess of its purpose. When you look at the purpose of the regulations in Regulation 2, it doesn't talk about any grant or giving any permit. So for 3.2 to purport to go into grants and who can do that, it's in excess of its purpose, and it's overbreadth its purpose. So it must be taken out. Okay. So that one I agree.
The government intends to introduce an amendment, an amendment of Act 703, and that is intended to completely ban mining in forest reserves. If that amendment happens, this LI will become useless, right?
Is that government wants to introduce an LI?
Mm-hmm. It wants to introduce an amendment to Act 703 to completely ban mining in forest reserves.
Yes. So that is where the ban can start from, because you see 2576 talks about the mineral rights vested in the president. However, it doesn't go beyond that. But when you come to Section 5 of Minerals and Mining Act, it says the minister acting on the instructions of the president. So that grant itself is based on 703.
Thank you.
So when you amend 703, you touch on the power to the mineral rights. So that will be okay.
Thank you very much, Kingsley. And Clement, you have the last 2 minutes that we have left.
Sure, Samson, thank you. Which is easier to do? An amendment of an act of parliament, or a revocation of an LI? An LI takes 21 days by a fraction of time. No debate, no arguments. When it comes to amendment of an act, it's a more detailed process. As I said, if the intention is to ban mining forest there, it starts taking this bad law off our statute. The law lacks legislative capacity, it is of no use, and it creates legal dissonance.
Clarify this small point for me. There's been the argument that, if you do a revocation, there are obligations already that we already have, and it will affect those who are already in the doing mining in the forest reserve, as if that began in 2022. What do you say? Okay. I suppose that's all time will allow us to continue for this discussion. I hope that we have been helpful to you by looking at the law more closely than you may have ever had the opportunity to look at. LI 2462, now amended, the controversial portion amended by LI 2464, correct? My guests have been Clement Kojo Akapam. He's senior lecturer at GIMPA, teaching the law. He's also in practice with Taylor Crabb, barristers and solicitors, and Kingsley Ekogura Say is in private practice. He has expertise in the area as far as environmental protection is concerned. I'm Samson Ladia Yanini. This has been The Law. It's your legal light. It is your health law.